suppression of turnover is there, or excess claim of input tax credit is there, or excess refund is claimed, or tax which is required to be paid is not paid, then the purpose of an audit proceeding is to examination of the records. So it is not with an objective to seize the document or the record or do any invasive action. It happens with the mutual cooperation. Many a times the department issues a letter, says that you please provide us this preliminary documents and records, and they ask the SSC to fill up a questionnaire. And once that is done, they analyze the data and the details and the documents. They may ask for some further information, and then they give an advanced date of visit to the premises of the SSC, where the team of the audit team visits the premises, examines the documents, records, and everything. And then if any discrepancy is noted, then they issue a audit report. And a response of the auditee is asked. Now, after the reply from the SSC is received, if the department agrees with what the SSC explains, then they are well within their power to drop the proceedings. But if they are not satisfied, then after conclusion of the audit, they may refer the matter to the jurisdictional officer to initiate action under section 73 or 74 by way of issue of a so-cause notice. So the audit team does not have the power to issue a so-cause notice. You see, ultimately the objective of all of these actions, whether it is audit or summon or search or seizure, ultimately the objective is to assess the tax, and none of these objectives can be fulfilled unless a notice under section 73 or 74 is issued. Now the power to issue notice varies. A audit officer is not empowered to issue a so-cause notice, but a team which is a team of search and seizure, for example, Bureau of Investigation or DGGI, Director General of GST Investigation of the Central Taxes, they are also empowered to issue so-cause notice. But an audit team is not, because section 65 subsection 7 very clearly says, where the audit conducted results in detection of tax not paid or short paid or initially refunded or input tax credit wrongly availed or utilized, then the proper officer may initiate action under section 73 and 74. Now, if we go by the definition, then the audit officer is also a proper officer. But usually what happens is that the audit team intimates about their audit report to the jurisdictional officer, and it is they who issues a so-cause notice. Now, summon is a proceeding where if any inquiry is either undergoing or a officer wishes to orally examine any person. So the purpose of summon proceeding is usually to oral examination. It might so happen that in the summon proceeding, a summon issue, a notice issued for summon to present a officer of a company or a SSE, they may ask to come along with some documents and records. But ultimately, at the conclusion of the summon proceeding, a statement of the person who appears before the officer is recorded and he is asked to sign upon it. Usually, such statement is in a question answer form where they ask a particular question and the SSE is supposed to give an answer according to what they understand. It might so happen that the person who is appearing before the officer may not have the immediate availability of the desired information which the officer is asking for. So in that eventuality, it is not mandatory that he has to provide everything in one go. He may say that at the moment, I do not have the information which you are seeking. So kindly give me a suitable date, and one can ask for a adjournment depending upon the voluminous information which is being asked for or required to be produced, and then one may appear again. But one thing is very important, that in the course of appearance of a summon proceeding, you give the statement on oath that whatever you are saying is true and correct. So in my personal opinion, it is advisable that I've seen sometime that a chartered accountant or an advocate under a authorization appears before the authority on behalf of the SSE. But I think it is not advisable, because whatever information you are giving, it belongs to the SSE. You are not the owner of that information. And since you are not the owner of the information, if you give any information which ultimately turns out to be incorrect, then you will also become responsible for such incorrect statement, and then proceeding can be initiated against you in person also. So it is always advisable that one avoids any attendance and any professionals, whether a company secretary or a chartered accountant or an advocate, avoids appearance in person in the response to a proceeding in summon. And in fact, there are judgments of the Honorable Supreme Court which says that in a summon proceeding, the appearance of an advocate cannot be allowed, because it is a very sacrosanct proceeding where the objective is to unearth the fact. So therefore, there is no necessity of an advocate or a chartered accountant or any consultant to be present while the proceeding of someone is going on. Though in few of the judgments, it has been held that the consultant or an advocate or a CA may remain present in the proceeding from a distance and watch the proceedings, where they can see what is going on, but they cannot hear and they cannot contribute to it. They cannot guide the SSE as to what should be his response or the manner in which he should give his response. So this one must keep in mind. There are other aspects of the summon also, which I will discuss in the course of today's this session. Now, let us come to the inspection, search, and seizure. Now, the audit proceeding always commences with a mindset that the SSE must be maintaining his records properly. It is never initiated with a mindset that there is an evasion of tax. But in order to initiate a proceeding of inspection, search, and seizure, it is necessary or mandatory in terms of Section 67 of the Act that the officer not below the rank of a joint commissioner has reason to believe. And this particular phrase, reason to believe, I will discuss in the subsequent part of my today's discussion. That he has reason to believe that there is a suppression of transaction of supply, or there is a suppression of the stock of goods, or there is an excess claim of credit, or there is any other contravention of the act or rules. So it always, the officer must have some material in his possession to come to that belief or the reason to believe that there is a evasion of tax. So the underlying principle is that the officer must have the some material in hand. It cannot be a mere suspicion. So reason to believe is not something which can be equated with the suspicion of the officer. So merely on the suspicion of an evasion of tax, a officer cannot authorize the inspection proceeding or search or seizure proceeding. Now we'll discuss the distinction between inspection, search, and seizure. The inspection proceeding is a very soft version compared to search and seizure, and it can only be done at the place of business of the concerned SSE. It cannot be done in any other place. But a search and seizure operation can be done at any place where the officer believes that there is some goods or books or accounts or documents which is secreted and which needs to be unearthed. So search is much more invasive than inspection. The power of the officer is much more wider. In the course of inspection proceeding, they cannot force open any part of the premises or break open any almirah box or any device or seize anything. But in the course of search proceeding, they may seize also, and they may break open also anything which they believe, wherein they believe that some books of accounts or goods or anything is kept. So the powers are also much more wider. But the officer not below the rank of the joint commissioner must authorize categorically whether they have authorized for inspection or whether the authority is given for search and seizure. Now contrast it with the power to summon. Now in the summon proceeding, any person can be summoned. Suppose the X Limited is being investigated, an inquiry is initiated against X Limited. Now, in the course of information, in the course of the proceeding, they feel that the attendance of a particular individual, say maybe a transporter or a the person who has supplied the goods or financed the company, or anybody they feel is in possession of any documents or records. It may be a chartered accountant also. So anybody can be summoned to present himself and faithfully provide all the details. In inspection proceeding, only the premises of the concerned offices or SSE can be searched, can be verified or inspected. But in a search or seizure proceeding, premises of any place or any location where the concerned officer has reason to believe that anything is kept secretly can be searched. And anything which the concerned officer feels has connection with the inquiry which is being done can be seized also. Now, as I said, that the reason to believe is not the reason to suspect. And there must be some material which must be available before the concerned officer. Now, another aspect, I think, which is very important is that I've come across several instances whereby the premises itself is sealed in the course of search and seizure proceeding. So that is not permitted. While the officer has all the power to seize anything which they believe is necessary to be seized for investigation, to come to a to come to a conclusion with respect to the undergoing investigation. But at the same time, they do not have any power to seal the business premises where the business is being carried on. Because such a action violates the fundamental right to carry on the business, which is guaranteed in terms of Article 19(1)(g) of the Constitution of India. So everybody and anybody, whether one is a natural person or whether one is an artificial person, everyone is entitled and has a right to, fundamental right to do business. And that right cannot be violated under any circumstance. So while the concerned authority has all the power to seize any goods or any documents or anything, but at the same time, they cannot lock, while they can break a lock to discover anything, but they cannot put a lock on the premises to stop the business activity. So this is very, very important. And I've cited one judgment of the Honorable Allahabad High Court in this particular site. Now, I will discuss some rights of the SSE in the course of a search and inspection proceeding. Now, first of all, a search warrant should be executed at the start, and it should be shown to the person in charge of the premises. And those who are entering the premises, the officers of the government, has to allow themselves to be bodily searched. Further, before commencement of the search proceeding, the signature of at least 2 witnesses who are independent witnesses of the same locality should be taken on the body of the search warrant. They have to disclose their identity with the identity card. And the entire proceeding should be made in the presence of the 2 independent witnesses of the locality. And the witnesses should also be briefed about the purpose of the search. So it is not that they remain a mute spectator. The witnesses should also be told about why this search proceeding is going on. And it is always mandatory that a lady officer should be there in the search team. So no search team without a lady officer can even enter the premises for the purpose of search. They can be asked to leave immediately. Further, the search and survey proceeding, even though we know that they torture and they continue it day and night, but it has been considered to be a violation of the human right if such proceeding continues till night. And there are some very scathing judgments of the Gujarat High Court and some other high courts wherein such proceedings were carried on for days altogether, and the officer stayed in the premises of the SSE in the night also. Further, the SSE or the taxpayer has a right to call a medical practitioner if he is not unwell, and also to have his meals at his regular time. Now, he may be eating meal at any point of time which he, according to him, is normal time. Further, it usually so happens that nobody is allowed to go outside whenever a search team enters a premises. The premises, till the time the search is going on, is virtually blocked. Neither any entry without the permission of the officer is allowed, nor exit without the permission of the officers are allowed. So, but at the same time, the taxpayer has a right to have his children permitted to go to school. One second, kindly give me one moment, please. So as I was saying that the taxpayer has the right to send his children to the school, then if any statement is recorded, then each page of the statement must be signed by the person whose statement is recorded. And whatever documents, goods, or records are seized, a panchanama should be prepared, and a list of all the documents or the goods or whatever has been seized should be annexed to that, and it should be acknowledged and signed by the owner of the premises. Now, one of the important questions which arises about if suppose any perishable commodity or hazardous commodity is seized, then what happens to that? Now, the officer has the power to immediately dispose of any such item which is perishable in nature, and it is also a principle of law that if one wants the release of the goods, then it can be provisionally released on execution of a bond and furnishing of a security or on payment of a applicable tax, interest, and penalty. And it is also a well-established guideline that if any seized documents or goods is there, then they should be retained only till the time they are required for examination or inquiry. If they are not relied upon, then they should be released immediately within 30 days of the issue of the notice. Further, the SEC also has a right to take a copy of all the important documents and everything and the records which is being seized, so that his business operation can go on uninterrupted. Further, if any goods is seized, then the notice has to be issued within 6 months. Even though this can be maximum extended up to further 6 months, but overall within maximum period of 1 year, the notice has to be issued if any goods is seized. Now, I have referred to this judgment of the Honorable Gujarat High Court, where the Honorable Gujarat High Court gave a very scathing remarks about the day and night operation which was carried on by the government officer by staying in the residential premises of the petitioner. Now, with respect to seizure of the goods, it might so happen that it may not be practically possible for the officer to take the custody of the goods. So in that scenario, they may issue an order where a symbolic seizure is made and a direction is given in a particular form which is called INS 03, that the owner of the premises will not move or part away or deal with the goods except with the previous permission of the officer. Now, this search seizure operations are very, very sacrosanct, and you see, they are proceeding which are treated as a the code of criminal procedure applies to search and seizure proceeding, and therefore one must be very careful about what one says and what one does not say. One has to cooperate during the entire proceeding. Otherwise, one may face action not only against under the GST Act, but also within the provision of the Indian Penal Code. And one must always answer truthfully whatever is asked, because any false statement is an offense not only under the purview of the GST, but also an offense under Section 181 of IPC and 191. And further, if any, suppose somebody helps, suppose not connected with that SSC, but if somebody is in any manner helps in secreting any document or destruction of any document, then it is an offense under Section 204 of the IPC, and one is liable to be punished. Further, one second, kindly give me one moment, please. Now, with respect to the copy of the document, I have already said that one is entitled to have a copy of the document seized. If it is not immediately provided, one should make an application for the copy of not only the documents which has been seized, but also the statement which has been taken. And one of the important things with respect to both the statement taken in the course of a search proceeding or in the course of a summon is that if by force or threat of arrest or any such coercion, any statement is taken, then one must make the retraction of the statement as soon as possible without wasting any time. Now, let us look at the consequences if suppose any goods is seized and ultimately it is declared by the court or any adjudicating authority or appellate authority that the such seizure was illegal and not in consonance with the law. Then one is not only entitled to the, suppose if the goods are seized, ultimately they become unfit for use or are destroyed or become obsolete, then the SSC is not only entitled to be compensated for the value of the goods, but one is also entitled to the payment of interest. There is a very important judgment, landmark judgment of the Honorable Supreme Court, wherein it was decided that public purpose is a precondition for deprivation of a person from his property. Under Article 300A, and even though Article 300A does not specifically say so, but a compensation is inbuilt in Article 300A. And there are several judgments of various high courts. I've cited two judgments of Honorable Calcutta High Court and one of Supreme Court, where the seizure was declared to be illegal. And Honorable Court not only directed the department to return the money value of the goods, but also the interest was directed to be paid. Now, with respect to the summon proceeding, there are some guidelines which has been issued by the department from time to time in forms of circulars and guidelines and FAQs, whereby it has been stated that summon should be the last resort when the SAC is not cooperating. And this should be least used against the top management. So only if the SAC is not cooperating by way of a phone call or a normal email, which is not in form of a summon, because the language of the summon is so harsh that it causes unnecessary mental stress and embarrassment to the receiver of the summon. So it is always avoidable to not formally issue a summon under section 70 of the Act, but instead make a regular communication by way of an email. It can be by way of a letter also, simple letter, or it can be by way of a phone call also to the SAC concerned, and seek whatever information or cooperation which the department is seeking. But there is no necessity to issue a summon necessarily under section 70 of the Act. Further is said that the language of the summon should be soft, so that it does not create undue stress upon the recipient of the summon. Further, senior management such as CEO, CFO, and directors, managing directors, or general manager, they should only be summoned if by summoning other lower level officers, the purpose is not served. And further, repeated summon should not be issued. Now, here we see a very common phenomena that nowadays someone has become a tool to harass a taxpayer, and they are repeatedly summoned to ask for this information or that information or the same information again and again. And in the course of summon proceeding, they are threatened either to admit a tax due which the SAT does not agree, or to make payment of the tax which the officer believes is liable to be paid even though the SAC does not agree. So herein, one of the matter which I did before Honorable Bombay High Court, the citation is there in this particular site, where the Bombay High Court came down very heavily on the department, asking them, why are you issuing repeated summon? And you must have a guideline that there should not be any repeated issuing of the summon. And after that, one guideline has been issued also, where it has been stated by the department that there should not be repeated issue of the summon. And as far as possible, the statement should be recorded in minimum number of appearances. Also, the guideline says that the statement should be recorded during office hours. Further, it has been said that we all know that sometimes the summon is issued, even though the said information is available with the department itself digitally on their own portal. So that also the guideline said should be avoided in order to avoid harassment to the SAC. If some information is always already available with the department on their own portal, then they should not seek it from the SAC. Further, the guideline says that one aspect which we see is that many a time it is a tactic of the department to call a particular person or a officer of the SAC and make him wait for long hours. Because they know that if they are repeatedly summoning a person and making them wait for long hours, then in order to avoid harassment, sometime out of the mental torture which they experience, they sign on the dotted line whatever the department wants them to sign. So in order to avoid such a scenario, now the guideline says that no person should be made to wait for long hours before a statement is recorded, except when it has been decided very consciously as a matter of strategy. Further, it says that all the summons issued must have a DIN, and the format of summon is also prescribed. And I think one thing which we must keep in mind is that one should not avoid attendance of the summon, because the consequence of the non-attendance are very serious. The summon proceeding is also covered by CRPC. So if one does not attend, then the non-appearance may initiate a proceeding in terms of the Indian Penal Code. Now the guideline says that if one person does not appear after 3 summon at reasonable interval, a complaint should be filed before the judicial magistrate initiating action within the purview of the Indian Penal Code. But it must be ensured before doing so that the summon has indeed been served upon the intended person. So it cannot be that they perfunctorily issue the summon and the person does not receive, and without examining whether the concerned person has received the summon or not, they initiate the proceeding within the purview of the Indian Penal Code. So there are various safeguards which has been issued in the interest of the SAC to avoid harassment and any coercive action. Now, some of the important judgments in the context of summon is, I have jotted down in this slide that in one of the case before the Honorable Bombay High Court, the court said that if the SSC has already furnished all the documents called upon by the GST authorities, then there is no need to call upon the director. It is enough if the consultant appears before the authorities and furnishes the documents. And even after that, if a necessity is felt that some director or senior officer will be called, only then they should be called. Otherwise, it should be avoided to the extent possible. And therefore, the summon which were issued against the directors were quashed and set aside. Now, the another issue which comes to my mind is that it sometimes so happens that summon proceeding or the inquiry is initiated both by the central GST authority as well as state GST authority. Now we know that section 6 subsection 2 clause B very clearly says that if the subject matter is same, then both the central and state authorities should not initiate investigation. Only one should do. This is to avoid harassment of the SAC. Now the question arises whether the summon is a proceeding. So there are contradictory judgments on this particular issue. One of the matter which I argued before Honorable Calcutta High Court, Raj Metal Industries versus Union of India. It has been reported, which I have cited here, that if the proceeding is already going on before the Central GST Authority, then the West Bengal GST Authority should not initiate the proceeding. But the Honorable Allahabad High Court has held that someone is a proceeding only of inquiry. So it is not a proceeding, in fact, it is only an inquiry. And the word inquiry in section 70 is not synonymous with the word proceeding, which has been used in section 6, subsection 2, clause B of the UP GST Act or the CGST Act. And therefore, they refused to quash the summon proceeding, which was simultaneously going on before the state as well as the Central GST Authority. Now, the another important aspect is the recovery proceeding, which is made more often than not in the course of summon proceeding or search and seizure proceeding. Now, here there are quite a number of judgments, and the number of high courts and the number of judgments are, all of them are on the same footing, that in the course of summon, search and seizure proceeding, there should not be forcible recovery of the tax. It is only after the assessment is done in terms of section 73 and 74 by way of issuing a notice, only then the recovery proceeding should be initiated. But without issuing a notice under section 73 or 74, no recovery should be made. But more often than not, such a high-handed action is being done by the department, and Honorable Supreme Court and High Courts have time and again has held such recovery to be illegal and directed the department in all such cases to return the money which has been forcibly recovered in the course of such proceeding. I've given some citation of Supreme Court, Jharkhand, Bombay High Court, Gujarat High Court. There are other judgments also. Now, one aspect which arises in mind is the evidentiary value of the statement which is extracted, sometime voluntary, sometime forcefully. So the law says that generally the evidentiary value of a statement made before a police officer under section 24 of the Evidence Act is not a valid evidence. Because if one is able to prove that if the making of the confession is caused by inducement, threat, or promise, then it will become invalid. But confessional statement recorded by the tax or revenue officer, even though they do not have the safeguard of section 24 of the Evidence Act, but still the courts have held that if the circumstance suggests that the statement was taken in duress or in not unfavorable circumstance, and the circumstance suggests that it must have been given in a by way of a threat or coercion, then in such a scenario, the statement cannot be relied upon for the purpose of conviction. Now, the another important matter is that many times you see the liability is assessed or determined on the basis of the statement of a third party. So what should one do in such a scenario? So if any so-called notice is issued or any proceeding is initiated on the basis of the statement of a third party, then it is always advisable that one should seek cross-examination of such a person whose statement is relied upon. Because time and again, it has been held by the Supreme Court and various high courts that if any statement is relied upon and if the benefit of cross-examination is not given, then it is a gross violation of natural justice and the entire proceedings becomes non-est and invalid in the eye of law. So without entering into the merit of the case, such a proceeding is liable to be quashed and set aside. So as soon as one receives any notice or any proceeding on the basis of statement of a third party, the first thing one should do is to write a letter seeking cross-examination of such a party. I have given various citations, which I'm not going to discuss. Now, with this, I conclude my today's talk, and I would love to have the questions of the participants. If anybody has any question connected to the today's topic, then please type your question in the question answer box, preferably. Mr. Manoj Kumar is asking if someone is issued for submission of document, can we submit online? No. A summon is always issued asking a person to appear in person. Now, the purpose may be to produce a document or give evidence, but generally, a summon is issued for the personal appearance. So, online submission of the document will not be sufficient. Okay, someone is asking what period the documents can be retained by the officer in seizure procedure. You see, the seized document, if they are not relied upon documents, then they should be returned within 30 days from the issue of the so-called notice. Search conducted under section 67(2). Can SCN be issued under section 73? Yes, definitely. If any search proceeding is conducted, then ultimately the object of the search proceeding is to detect any unpaid tax or any excess input tax credit or any evasion of tax. So whether it is an audit proceeding or search proceeding or summon proceeding or audit proceeding, the outcome of each proceeding should be issue of notice under section either 73 or 74. Okay, Mr. RK says that since many of the cases cited but have not been explained, kindly circulate the PPT of the presentation. Yes, I have already explained all the cases which I have cited. The ratio of the judgments which I have shared in my PPT, I have explained to all of you. If anything you have not understood, then you are welcome to ask me again. I will clarify. It is only that I have not read out the judgments which I have referred to in my citation in order to avoid the wastage of time. So, and I will certainly share the PPT of today's presentation. I believe the PPT of all the previous presentation is available with you. If not, then you write to the tax scan management, the email ID which is available with you. They will certainly give it to you. Okay, one of the question is recording of statement by the authorities should be within the office hours. Now you see, this is the official circular of the department that it should be within the office hours. So now we know very well that every time it does not happen the way the guidelines are issued. And if suppose any violation of their own guideline is made, then we can certainly approach the court for taking the department officer to the cleaners. In case of audit conducted for any particular period, is it mandatory to file annual return in form GST R9 and 9C? No, audit conducting of audit has got no connection whatsoever to the filing of return, annual return. Even if the annual return is not filed, the officers may do audit or conduct audit. But practically it has been seen that in most of the cases, they are initiating proceeding only after the annual return is filed. You see, since audit conducted by the department, so what is the necessity of filing annual audit report? Annual, sir, auditing superintendent is in practice of issuing SCN and asked to file reply before the range superintendent. It is correct. You see, the law does not prevent. As such, law says that the proper officer will issue the so-called notice. Now, if the audit team officers are appointed as proper officer, then there is nothing wrong in audit team issuing so-called notice and asking you to file reply before the range superintendent. In section 67, the word secreted is mentioned, but it rarely comes into play. All the books and goods are readily available. Yes, they are available in the case of honest taxpayers, but there are dishonest taxpayers where it is not readily available. So, and they are secreted. So, therein the government officers have to utilize their courtship power to break open or to unearth the secreted documents or goods. On what grounds can the search be called illegal? You see, a search can be called illegal if it does not have in the primary place the required authority of an officer not below the rank of joint commissioner. And further, all the procedures which are mandatorily required to be followed. For example, the requirement of presence of two independent witnesses, the search warrant, the signature, the offering of the officers for physical checking by the SSE, both at the time of entry and exit, the presence of a lady officer in the search team, if any of the condition of conducting search is violated, then the proceeding can be called illegal. Is ASMT 10 issued on some paras and closed after replying? Then can department issue ASM 10 on different para again, or department can conduct audit? Mr. Sanjeev Goski, I could not understand your question. Please reframe your question. Post research under section 67, GSTR 3B was filed, but the department issued notice under section 74 after 2 years, demanding apportionment of tax paid towards interest and penalty. Can the department do so, as tax has already been paid? You see, the notice can always be issued, even if suppose you have filed your GSTR 3B return, but if there was a delay, then notice can be issued under section 74 if there was a deliberate intention to avoid payment of tax. So they are well within their rights to ask for the payment of interest as well as penalty. Okay, one of the question is, when the audit team asks for payment of RCM which are not paid along with GSTR 3B, can such payment under RCM is claimable under IPT? What is the meaning of IPT? Please explain. Okay, someone is asking time period for issuing SMT 10 or audit notice, or someone under GST. There is no time period for audit notice or summon, but for issuance of the SOCOS notice, the time period is prescribed under section 73 subsection 2 as well as subsection 2 of section 74, which is 3 years from the the issue of the order period is 3 years from the due date of the furnishing of the annual return. So within 2 years, 9 months of the issuance of the filing of the annual return, notice under section 73 may be issued, and in section 74 subsection 10, the order must be passed within 5 years from the due date of furnishing of annual return, and notice should be issued prior to 6 months to the time limit prescribed, which is specified in subsection 2. I'm a co-developer of SEZ. The department is asking to pay RCM on lease deposit. My argument is that subsection 16(1) and notification 32(7), I am not liable. The summon is issued for this. Now, if the department is already having the information to wherein they already know that the RCM on lease deposit is payable, then what is left to further investigate or inquire? Because the purpose of summon is to inquiry. If the inquiry is already done, then I don't think this summon is lawful. This is only a tool of harassment, and I believe such a summon is liable to be set aside if you approach the court. Okay, friends. So I don't think we have any more questions. So with this, I would like to conclude today's session. Madam Asarwa, are you there?
Yes, sir.
So let us conclude today's session, and we can announce the next date.
Yes, sir. You can.
So let us do it on 8th or 15th. Which one we should do?
We can do at 8, sir. On 8.
8.
8th of April. Okay, noted, sir.
Or okay, I think let us do it on 15th, because
Okay.
8th I have some difficulty. So let us do it on 15th of
No
April.
issue, sir. We can fix at 15.
Okay. So somebody is saying that all presentation notes of day 3, 4, 5, 6, and 7 should be shared. So, madam, kindly share the presentation once again with everybody.
Yeah, sure, sir.
So if you have any missing presentation with you, I will. I don't remember whether last date's presentation I mailed to you. So I will
It's
again
not
mail
shared,
you
sir.
the last day's presentation and today's presentation,
Yeah.
and kindly check with which if you have all the other presentation, and then
Yeah,
share
sure.
all the presentation with everybody till date.
Yeah, we can do that, sir. We will share it to all the participants.
Yes, yes. Okay. Thank you very much.
Thank you so much, sir. Thank you,
So
everyone.
next session is on 15th.
Yeah, noted.
Okay. Thank you.
And one more thing I want to add, that if there is any concern, queries regarding the PPT and the recordings, please do contact in this number. I am giving my number here. I'm giving my number here in the chat box. If there is any concern regarding the PPT and recordings, please contact in this number. Shall we wind up the session, sir?
Yes, yes. Thank you.
Okay, thank you.
Thank you.